Using a drill.
Good afternoon, everybody. Aaron Keller here along on the Law News Network with Christi Kunzig, who's joining us this afternoon for a little bit of analysis on the cases we're following. Welcome back.
Thank you for having me.
So we're talking about the Adam Matos case for now, and it just seems like such a strong case for the state. We've got a lot of evidence. We don't have a ton of smoking gun evidence. We don't have eyewitnesses, but it just seems based on the facts that this ought to be a pretty surefire conviction. Do you agree?
I absolutely agree. I think not only do we have a lot of evidence, we have a lot of bizarre evidence, like the fact that he's saying that they went to West Virginia and they're on vacation, or that he's selling their dogs. That's pretty interesting, and living at their house. I mean, just all of these facts combined are just completely bizarre and really strongly point the finger at him.
It would seem that way to me as well. I mean, you know, not only that, but look, he claims that he left town with the child, okay, the 4-year-old, at the time 4-year-old, and then neighbors, pizza delivery drivers all spot the child there at the residence with the defendant. So why is he claiming he left after Megan Brown, the victim, called police and said that he had threatened her, okay, and then he says he's gone, but everybody else says he's still there?
Right. I mean, I don't think he's that credible, but that's going to come for the jury to decide. And he has really nothing else. The only other thing he can point to is some potential ex-lover of Megan's boyfriend, Nick Leonard, saying that, you know, maybe she was stalking them and maybe she did it. And I think he's just trying to put the blame anywhere he can. You know, it was really horrible for him that he did an interview with the Tampa Bay Times, and that was pretty interesting. And in there, I think he kind of hurt himself with a lot of the things he testified to, saying, oh, you know, I don't know how I got her son and how we wound up leaving, and I don't know what our last argument was about and the last time I spoke to her. And you know, I think a lot of those things are going to be pretty detrimental, because if you're saying that you left with your son but you don't know how you got him or when you planned on bringing him home, that's also really going to hurt you.
You know, he's telling different versions of the story to all these folks that showed up to answer the Craigslist ads, and we heard from them on the witness stand yesterday. He had placed these ads for televisions, the dogs, okay? And these just aren't any dogs. These are purebred animals that normally, as we've heard from multiple witnesses, fetch a pretty high price. And meanwhile, he's trying to pawn them off on Craigslist for rock-bottom prices that just don't make any sense to anyone who's immersed in the world of loving dogs. He's trying to sell the dogs, he's trying to sell a phone, a laptop, you've got some audio gear wrapped up in there as well. And some of these people are just like, hey, we're not going to buy this stuff if we can't come in the house and test it out, like the TVs. Would you buy a TV, regardless of whether it's $100 or $2,000, off of someone's front porch if you can't plug it in and see if it works?
Absolutely not. That definitely makes you raise some eyebrows and say, all right, what's wrong with this? Why won't they let me test it out here? And now, you know, it seems like it's not what they think. The TV is probably in perfect order. It's just that there may have been some blood or dead bodies or remnants in the house that he didn't actually want them to see.
Yeah, you know, it's like first the defendant is saying, okay, I'm not going to let you in because the house is a mess. So then the people leave, and then he keeps messaging them saying, oh, I'll drop the price down, come back, come back, come back.
Right.
He tells another one of these Craigslist folks that the reason that he's trying to sell things at such cheap prices is because he and his girlfriend were having some trouble. The presumption there was that it was financial trouble. But, you know, again, it's like the excuse changes from person to person to person to person to person.
Right, which is something that, you know, the jury is going to consider when they're trying to say, you know, do these facts line up in his defense? Is he a credible witness if he does decide to take the witness stand, which who knows? But, you know, I think they're going to have trouble believing him or any stories that his lawyers put forth, because again, he changes for everyone. He really doesn't have any solid proof, and there's a lot of evidence stacked against him.
You know, one of the pizza delivery drivers was on the stand yesterday, and she said one thing that stuck out to her about the transaction is that the 4-year-old child answered the door. It's raised a lot of questions that many of us have had here for quite some time. Was the child there to witness the murders? Was he there in the house while the defendant, again, presuming that the defendant is guilty, was the child there in the house during the cleanup? Well, many of the witnesses would suggest all of the above. The child answers the door, the defendant comes out and eventually gives the pizza delivery driver a $15 tip, right, which the driver thought was astronomically high. I mean, I don't order pizza delivery very much, but apparently that's a huge tip.
That is definitely a big tip. And, you know, we don't have any testimony from any witnesses who say, oh, I was babysitting the child and I dropped him off and Matos took him. You know, there's nothing saying, oh, I was watching the child at the time this may have allegedly taken place, or, you know, the time that we think, as I think it was the 28th, you know, through the 29th, and no one's saying, oh, I was watching the child during this point in time. There's just nothing there. It's lacking. You know, and I also found it pretty interesting. He wasn't charged with kidnapping, which leads me to believe that I guess there was no support paternity. There was no residential custody assigned to Megan. But, you know, it's just kind of interesting that he's taking the kid and there's no charge against that for him.
Yeah, you know, and it raises another question as to why he came to live in Florida in the first place with the Brown family that had moved down from Pennsylvania. Apparently the Browns were concerned about moving down there on their own and not bringing him along because of that very issue.
Right.
You know, there are all of these interstate family law issues that come up when one parent tries to move out of state, regardless of the reason. You know, it just causes a list of problematic legal issues that can pop up, and so the Browns were like, well, let's bring him down to Florida with us. He'll have to get a job and contribute to rent. They were renting a home from someone else, and then less than 2 months later, everyone shows up dead except for Adam Matos, the defendant, and the child.
Right, which is another issue that the jury's going to have to look at. How did he escape this? And we know, based on the evidence with the blood and maggots and shell casings that were found at the scene, we know that that is where they were murdered, and then their bodies were later disposed of about a mile away. So how is he the only one, him and the child, how is it that only they survived and they have no idea as to what happened to the rest of the family?
Exactly. You know, the last witness on the stand yesterday was this Walmart cashier who talked about this just very strange transaction where he shows up, he meaning the defendant, shows up, I believe this was on the 29th, 11:30 to midnight, somewhere in there, in the electronics section. Okay, not the front section where you go to buy just about everything you want, but in the electronics section where there's that one cash register back there. He tries to buy a PlayStation 4 and a video game and a shovel. And
which
the cashier,
is always how you buy those things.
Exactly. You know, and the
shovels.
cashier just thinks that it's odd, okay? So initially the cashier's just like, what's up with this? You know, then the transaction doesn't go through. And so Matos is like, well, then let's get rid of the video games. I really need this shovel. I don't think that I've ever seen in my entire life anyone buying a shovel just before midnight.
Right, that's also odd. And what do you need to use this shovel for so badly right now? Especially, we know that he loves video games. So for him to give up the console, the game that he wants to get, and instead purchase this shovel, you know, that's going to be hard for him to explain away.
Exactly. So that's where the trial witnesses sort of led us yesterday. Still waiting to see exactly who else is going to testify, but it would seem to me that the big witness that we should be expecting is probably going to come up near the end, and that's Ryan McCann. He's the neighbor that's going to link this all together and say, no, wait a minute, Adam Matos was there. He was there after the crimes are believed to have been committed just before midnight on the 28th. Well, this neighbor can testify not only was he there just after midnight on the 29th, but he was wet, sweaty, something seemed odd, and also was with this defendant many times in the subsequent days.
Right, it seems like they spent a considerable amount of time either talking, he drove him to the bank to cash a check, so they did a lot. And then there were a lot of conversations that the two of them had that really raised McCann's eyebrows, saying, you know, do you have surveillance equipment around? And things like that really got him to say, yes, I do, but you know, he didn't.
Yeah, why are you asking me about that?
Why do you need to know this? And, you know, I think there was also, prior to this incident, he had picked his lock, so that kind of also probably jogged his memory, saying, all right, you've picked my lock before. Why do you want to know if I have surveillance? What do I have to worry about? Meanwhile, it wasn't him that he had to worry about. It was you know, the people he was living with.
Yeah, there are a lot of bizarre circumstances tied into this case. So we're going to switch and listen to a little bit more of the testimony of Jamie Martin. This is one of the forensic examiners in the case. We're going to be back to talk a little bit more about Oj Simpson in just a few minutes.
Yes, an electric grill, a cordless grill.
Exactly.
Okay. Showing on that display states 250. I believe you testified already that that was also the contents of that yellow and black.
Of the yellow DeWalt bag, yes.
And you also see some drill bits in that that group of items?
I believe there was a few. You can see a couple there. I believe there was a few in that.
Okay. I'm showing you states 251. And that's the other tool.
The bucket bag? Yes.
That was in the truck?
Yes.
Okay. I'm showing you states 252. Is that once you remove that tool bucket we just looked at in 251 and the contents that were within it?
Yes.
Okay. And I'm showing you states 253. That was another item that was within that blue truck?
Yes.
While we're at it, since I forgot to display it. I'm now going to display states 236. You can just remind us what that was.
That's that settee set, the 2 chairs and table on the upstairs patio, which was, I think, room O.
And was there a box of Camel cigarettes?
Yes.
And you may resume your seat. Actually, I'm probably going to have you sit down again in just a second.
We can
I
get
forgot about these
steps in.
two. Actually, I want to go show the defense these 2 photographs. Showing defense counsel state exhibits 254 and 255. Were you involved in going up in a helicopter in order to take some photographs of the area of 7709 Hatteras Drive and other areas of interest in that surrounding area?
I was?
And I want to show you state's exhibits 254 and 255. Do you recognize those?
Yes, I recognize that as a residence at 7719 Hatteras Drive.
And that's state's 254?
Yes.
Okay. And states 255, is that an aerial view of the end of the Hatteras Drive cul-de-sac, I guess?
Yes, towards the west, it looks like, from the residence. Yes.
And what date did you go up in the helicopter and take those photographs?
I believe it was Saturday, September 6th.
Okay. And if you step down, let's look at these real quick. Displaying states 254. And just acquaint us with what we're looking at there.
This is the residence that we're talking about, 7719 Hatteras Drive.
And when you responded on September 4th, 2014, was there a significant law enforcement presence outside of that residence?
There was?
Was it similar to the number of cars that we see located there in this photograph?
Much more than that, actually.
Okay. Were there lights, blue lights, red lights?
Yes.
Was there a roadblock in that area?
There was, further down on Old Dixie Highway both directions. The road was blocked, and all that was allowed in was persons in agency vehicles.
And I'm displaying states 255. Is this Hatteras Drive right here?
Yes. Yes, so
This would be the end of the cul-de-sac, I guess, of Hatteras Drive?
that's correct. And the residence, although not in this picture, would be over in this direction.
Okay. Now you may resume.
Sure.
I'm sorry, did I move 254 and 255 in evidence?
No, haven't.
May I move in evidence?
Thank you for your objection.
No objection.
So be so moved, 254, 255.
Going back to the blue truck that we saw photographs of that you assisted in processing, involved in that processing, did you try and lift some fingerprints for evidentiary value?
I did.
In particular, can you tell me about JM 126? 126.
JM 126 is a latent fingerprint lift from the inside or internal side of the passenger side window.
Okay, and did it appear to have ridge details such that it might be of value to compare?
As my recollection, yes, it did.
Okay. And you collect that so it can be processed in the future?
Yes, it would be packaged similar to like the swabs are, put it in its own package and submitted, as you said, as item JM 126.
Okay. I'd also like to show you State's Exhibits 256 and 257.
Mm-hmm.
Are those both photographs that were taken when you were up in the helicopter on September 6th?
Yes, aerial photographs.
Are they fair and accurate representations of the way the area of 7719 Hatters Drive looked back then?
Yes.
I do not yet, Judge, thank you. I did not present those. I'm showing you states 41 and states 42. Already been entered into evidence as aerial views of towards the end of Old Dixie Highway. Do you recognize those?
I do.
Are those photographs that were taken while you were up in the helicopter on September 6, 2014?
They are.
Do they accurately reflect the way the area appeared at that time?
They do.
Okay. Finally, I'm going to show you States 54. Is that also an aerial photograph that you took, or that you were present while it was being taken on September 6th of
It is.
2014?
Yes,
Did it accurately depict the area as it appeared on that day,
it does.
aside from the colored stars that are on it? All right, Judge, may I have just a moment?
You may.
We are going to take a little bit of break right now from talking about the Matos case to talk about something we've been talking about all day here on the LawNewz Network, the Oj Simpson case. Now, TMZ reported yesterday that he apparently, at least according to them, was somehow drunk in a Las Vegas bar. Now, why is that an issue? Because he's out on parole, and that's a big no-no. Well, today, his attorney says the whole story just doesn't make any sense. So, what do we make of it?
I would expect his attorney to say something like that because that's his job. He's there to defend him and try to say, no, that absolutely isn't what happened. But on the other side of things, this is a problem if he did in fact have too many drinks and violate his parole, because he's allowed to have a drink, he's not allowed to drink in excess. And it's not going to be a high burden to prove if this did in fact happen.
Well, you know, is it a he said, she said, even within the hotel staff community? Because apparently the hotel is saying this isn't quite the version of it that we believe happened.
Right, so that's all going to have to come out. When you're doing parole violations, it's kind of preponderance of the evidence rather than beyond a reasonable doubt. So it's more of a civil standard. And you don't have the option of having a jury. It's always just with the judge. And you just have a less formal hearing. And you have to produce some evidence that shows more likely than not he was excessively intoxicated. So, you know, depending what the bartender says is going to be it's going to really play a big role in whether or not they revoke his parole.
Do you think that it's going to go to that point where people are going to really dig into this and then, you know, try to drag him back into the system? And then what? Then where are we? We're going to be talking about this for the next, you know, how many years as well?
Yeah, that seems to be the case with OJ. We just love to talk about it, and I don't think this is going to be an exception. I mean, it's already been all over the news. It's been on every radio station. Everyone's talking about it. So I think it is something that they're going to look into, and if they do have the ability to bring it forth for a hearing, we'll be talking about it for a lot longer.
Well, what do you make of this claim that his attorney made here on the LawNewz network where he said, okay, well, you know, OJ is allowed to drink, but not to drink in excess, you know that. And he said, you know, Simpson didn't show alcohol in his system, but that test took place 12 to 16 hours after this incident either did or didn't occur. I mean, 12 to 16 hours later, that's enough to get alcohol out of your system.
Yeah, that's definitely a lot of time. And again, because the standard of proof is reduced and it's just a preponderance of the evidence, which is just more likely than not, they're not going to necessarily have to rely on that BAC test. They can have someone say, oh, you know, I served him 18 drinks and they were all hard liquor, you know, and that could be enough to say, all right, yeah, it's more likely that you were drunk, and that's a problem.
Is it going to be a problem for the authorities if they only have one witness, though? You know, if one witness says he was intoxicated and then a couple others say either I don't know or I didn't think he was or he didn't look like it, you know, can they still turn around and say, no, we're going to lock you back up?
I mean, it depends. If the bartender is the most credible witness and then all the other witnesses are saying, I have no idea, then they're kind of shot. If they're saying, no, I was sitting next to him the entire time and he did not drink that much, then it comes down to a credibility issue. Who does the judge believe? Does he believe the bartender or does he believe this random person in a bar? So it'll really be the judge's determination.
Well, you know, that's the ultimate credibility factor right there. So, you know, part of me has to feel a little bit bad for the hotel because now they're in the middle of this huge situation that could potentially, if we're to extrapolate the logic out at the end of the chain, result in the most popular criminal defendant in the last 100 years in the United States getting in trouble with the parole board.
Right, and you know, now they had to ban him so that he can't even come back to that hotel because they've already had enough trouble from this. He had to be escorted out by their security. So even if he wasn't excessively drunk, there was some type of issue there that he had to be escorted out of the bar.
You know, what do you make of this statement from his attorney? He said, Mr. Simpson did nothing wrong, but his judgment needs to be highly tuned so he doesn't put himself in these situations. Now, wouldn't one think that of all people who should have a highly tuned perception of the way the rest of the world is looking at you, it would be Oj Simpson?
If the criminal justice system worked the way it was intended to, yes. After going through the trials he's gone through and the cases and everything he's been through, he would learn. But it seems like he is not, and that clearly he is someone who makes poor decisions, and he's going to continue to make these decisions.
Yeah, I mean, I had to just stop and think about that for a little while and say, well, you know, I just didn't fall off a turnip wagon the other day. I remember this criminal trial, and I know there was an acquittal, but then we've got civil suits, we've got this, this Las Vegas incident, parole hearings, you name it. This other interesting little tidbit here. You know, the promise was always that he was going to move back to Florida, but he's still hanging around in Vegas because apparently the full permission to go to Florida just hasn't either taken traction or it hasn't come through yet or whatnot. And his attorney said, look, he needs to focus on keeping squeaky clean here in Nevada so that he can go to Florida, which is where he's trying to keep his money stashed away from the Goldman family.
Right. Now, his attorney is right that he does need to try to keep himself out of trouble. He does need to stay squeaky clean, but that doesn't necessarily mean he's going to do it. He needs to do it in order to not violate his parole. But it's not looking like he's actually doing that. I mean, regardless of whether or not he was intoxicated, he was escorted out. So something was going on. There was something he was doing wrong.
You know, what do you make of these parole standards where someone on parole can drink but not to excess? Why not cut a standard that just says you can't? I mean, I'm not an expert in this area of law, so you may know more about it than I do, but it's just one of those things that, like, you inject alcohol into a situation with someone, anyone, any person out on parole. Part of me just sees that being a slippery slope.
The only thing I could really think of why they're not going to cut out alcohol entirely, and this is probably a far-fetched reason, but I could see a case where, let's say, I'm on parole, but I'm very religious and I want to go to church on Sunday, and you have a sip of wine. Are you now in violation of your parole? Because you had some alcohol, you didn't drink in excess, and it's not a problem. But I could see that saying, oh, you violated parole, and now here's another crazy case that we would have to discuss here.
Yeah, well, I didn't think of that right off the top of my head. I'm pondering about it a little bit here. I could see that case, but hey, then let's see that case. I would look forward to hearing that case. I mean, is a court going to come down and say the interests in society, in this case, override? If you want to have wine as part of a religious service, then, drink the grape juice instead. I don't know. And I'm sure that people religiously minded will complain that that's the improper way to analyze the situation. But parole is a privilege, it's not a right, and there's always a leash attached to someone who's out on parole.
I agree, but I also think, you said it perfectly, they're on a leash, so we're testing their freedom. Can we release you back into society? Once you're off of parole, you can have a drink, and we're not monitoring you anymore, so let's test you. Can you go out to a bar, have a drink, and control yourself and not be intoxicated, to the point where it's a problem and we now have to take you off of parole?
Well, let me flip the logic the other way. Is this a sneaky thing where we'll say, well, you can drink, but if you get in trouble, you're in big trouble? Is this something that is a way to test someone's freedom and to see whether parole really is the proper privilege?
I think it's a good way to kind of test out the waters and say, all right, you know what? Here's someone, we're gonna release them into society, but let's just make sure that they're capable of that and that they're not going to be brought back here, the day we let them out.
Well, let's get into the core crux of what may or may not have happened here. The hotel said to LawNewz.com, the alleged reports that are circulating about this incident are inaccurate, but the hotel wouldn't go into details and say, hey, look, our guests under our company policy deserve a degree of privacy. Well, that makes sense. If I were a guest at a hotel, I probably would appreciate that as well. That said, this is Oj Simpson, and if half your staff is going to get called to testify, then what?
Well, I think that's a smart move because you're going to be really publicized right now, and if you want other people to stay here, you want them to know that you have them in mind and that you're not going to violate their privacy, regardless of whether or not they're a celebrity, because maybe other celebrities are going to stay at this hotel as well. You never know. So you don't want them to say, oh, private people, you have rights. Celebrities, we're just going to tell everyone everything. And again, maybe they're trying to stay out of it as much as they possibly can, which is hard for them to do. But again, we also have to look at the source. It's TMZ, their gossip website. So take them, with a grain of salt.
Exactly. Okay, so I'm sure that it's a matter of perennial debate at this point as to whether or not it's a good idea or a bad idea to ban Oj Simpson from your premises if you're a hotel owner in Vegas. Would more people come to stay thinking that they're going to belly up to the bar with this guy, or would people avoid the place because he might be bellied up to the bar?
Right.
That one will be a matter of debate forever, I'm sure. I don't know if we can solve it.
I completely agree. I think, you might be thinking twice if he's constantly getting escorted out by security. Maybe I want to stay out of that bar.
And then that's an if. Is that exactly what happened? So,
yeah.
Well, we're going to have to wait and see how this plays out. It's possible that the state could try to move forward, that authorities could dig into this a little bit more. I'm certainly curious to see what the next step is in this is going to be. Or is it going to be a case where authorities are like, we don't pay attention to gossip?
They really shouldn't. But at the same time, if you have someone knocking on your door saying, hey, here's an allegation, you can't ignore it. As we saw in the Matos case, you cannot ignore when people are saying, hey, there's a problem here.
Oh, exactly. And a perfect way to switch back to this now, because we're going to listen to a little bit more testimony in that case. We've got another forensic examiner who we want to bring up in a second in the Matos case. But look, this is the second of 2 trials we've covered back-to-back in Florida that have really gotten under my skin, because Florida is a state where it is not a so-called mandatory arrest state. In other words, when there is a report of domestic violence, there is not a provision in Florida law that there be an immediate arrest. We've got the Matos case where there are serious threats lodged on the morning of the 28th, and then later that very same day, investigators believe 4 people were murdered by the person one of those victims called police to complain about. The case before the Matos case that we covered in Florida, the Luis Toledo case, the same thing.
Right.
That case involved a complaint the day before murders were said to have occurred. And in that case, you've got a mother and 3 children dead. So I'm sitting here saying, okay, look, I know these mandatory arrest laws are not popular in many echelons because some people say they result in a huge explosion in the prison population, basically just to give somebody a cooling off period. On the flip side, in states that have very strong mandatory arrest laws, a lot of people say they save lives. Do you have an opinion one way or the other on this?
I completely do. And I think that not having the mandatory arrest, I can see benefits to it because there are a lot of repercussions, and there can just be allegations of domestic violence. It doesn't have to be proven. It can just be, I call, and all of a sudden you can no longer get a pistol permit because there are allegations in some places. They're that strict. Then again, you look at cases like this and you're saying, well, these are 4 lives that could have been saved potentially if this guy was able to cool down and maybe not overreact. So I think I'm definitely in favor of the mandatory arrest, even though it's just based on allegation. It does have some pretty harsh repercussions.
Yeah, one of our other guests said here, look, the jail cell is not called the cooler for no reason in particular. It's specifically called that because people tend to cool off and realize that things are severe.
Right.
Now, look, I think it would be a problem if the law said any report of domestic violence results in a 3-day chill in the cooler, because that wouldn't make sense. Then people are going to be calling the police on one of those. Oh yeah, this happened, that happened. Well, there's got to be some credibility to it. And officers who are on the streets day in and day out, they can usually tell when somebody's telling the truth and when somebody's lying. Look, I know there are cases where police mess that up, but for the most part, I put trust in a good percentage of officers to be able to ferret the truth out from something that's made up. And you got to have probable cause to make an arrest, and police know when to look for that. Some of these laws say there's got to be some secondary indication. If it doesn't look like anything is amiss, there's no arrest. If the house looks like chaos and somebody has red marks, well, that's another set of indications that would lead to probable cause. Then you can make an arrest. Okay, look, just let the situation diffuse. Let the courts deal with it from that point. And maybe some of these murder cases that we're covering here at LawNewz wouldn't be murder cases. I
completely agree. I think if you remove them from the situations and obviously took away their opportunity, then these things wouldn't result. But I don't know. I just completely agree. I don't see any real reason not to have the mandatory arrest. Like you said, you're not being put in the cell for 3 days. It's just one day, and that's pretty much it. You have a cooling off period, and then you're released, and hopefully by then you're not as angry, especially when we're looking at Matos. Here, people have said that he tends to overreact, have violent outbursts. So maybe if you put him in a cooling off period, he wouldn't have reacted the same way the next day. He would have said, all right, I'm okay now, let's try to handle things, and we'll talk again. And, you don't know. He could have wound up, anything could have happened, but there's a likelihood that they would have survived at least another day.
One would hope, and one would think.
Yes.
So let's listen to some more testimony from the case. Again, a reminder that testimony will resume live on Monday because we're celebrating the Veterans Day holiday. The court is not in session today. They're going to come back into live session on Monday. In the meantime, we will continue to review the case. This is some testimony from Michael Coates. He's another one of the many forensics examiners who has taken the stand.
Please introduce yourself to the jury.
My name is Michael Coates, COATS. I work for Pinellas County Sheriff's Office.
How were you employed back in September 2014?
I worked for Pasco County Sheriff's Office as a forensic investigator.
And as a forensic investigator, was your job description the same as what Jamie Martin and Rhea Clark's would be?
Yes, it is.
Okay. So again, you don't carry a gun, you don't chase suspects, you don't interview witnesses?
No,
Okay.
not at all.
You document the crime scene and search for things, look for things, process things?
Yes, I do.
Okay. I want to take you back to let's start with September 5th of 2014. On that day, did you go to the dead-end berm area of Old Dixie Highway?
Let me refer to my notes real quick. Yes. Yeah, it was on a Friday.
And so Friday, September 5th, and when you went out there, were the bodies still present at the scene?
No, they were not.
And when you were there, did you notice any odors?
Yes, there was very foul odor. A large area of the grass was matted down, and it smelled very heavily of a decomposition smell.
So even though the bodies were not there anymore, the odor was still terrible?
Yes, you could smell it before you walked up to the area.
Okay, and while you were out there, did you use a metal detector over that general area?
I did. I swept the matted down area and the area leading up to that area.
And in those particular spots, did you find anything or detect anything with a metal detector?
No, I did not.
I want to turn your attention back to 7719 Hatteras Drive. Were you involved in assisting the search of that residence?
I was.
And I understand you processed the laundry room, which we've already seen photographs of.
I did.
And other than some of the dog feces on the ground, was there anything really of particular note in the laundry room?
No. I collected a couple items from there. I don't believe there was anything in there.
Okay. Now, I really would want to focus on the east side of the residence, outside of the residence. You know the area that I'm talking about?
Yes, the exterior of the house, correct?
The exterior of the house?
Yes, sir.
Was there an area of loose dirt?
Yes, there was.
And were you involved at all in the processing of that area?
Yes, I was.
Can you describe for the jury what your involvement was?
Let's see. On Saturday, I went out there and Supervisor Solinsky asked me to sweep the east side of the house. There's a large lawn area with a metal detector. And then she also asked me, she pointed out an area of soft sand that was directly next to the house. And she asked me to sift through that area. So I, for the next 2 days, I believe, I dug a hole and sifted through the sand.
Okay, and you said Saturday, that would have been September 6th?
Yes, sir.
Okay. I want to show you some photographs that have already been shown to defense counsel, states exhibits 258 through 261. And you recognize those?
Yes, I do.
And are they fair and accurate depictions of the hole that you dug and the thing that you found in it?
Yes.
Judge, at this time, say would like to move States Exhibits 258 through 261 into evidence.
Any objection?
No, Your
All right, also move.
And in particular, what'd you find in there?
After digging for a while, I came across like a sticker label, and I opened it up and looked at it, and it was an Ames shovel label. It was torn, but it was a piece of a label like on a brand new shovel you find in the store.
And where exactly did you find it? Was it lying on the ground?
No, it was probably about 1.5 feet, 2 feet down. Like it was down towards the bottom of the hole that I was digging.
Okay. Did anything, well, let me show you States Exhibit 262, which I already showed to defense counsel for identification. You look in there and tell me if you recognize that.
Yes, I do. It's the label that I dug up.
At this time, say would like to move State's Exhibit 262 into evidence.
Any objection?
No objection.
All right, 262 will be moved in.
Judge, may the witness step down and display the item.
You may.
If you could show that to the jury. After you dug about 1.5 to 2 feet deep, were you able to dig any further?
No, I hit what I felt like was sediment.
And sediment, what do you mean by that?
It was basically the just the hard dirt, like it hadn't been disturbed. If you dig a hole that has something like that, if it's been dug up once before, it'll be very soft because the earth has been disturbed. So when you fill it back in, it's a lot softer. And when you're digging a hole or when you're digging in an area that hasn't been disturbed, you're going against nature and time and everything, just compacting it down. So I hit an area and it just kind of stopped.
Okay, was there an area that was like lime rock?
Yeah, it felt like lime rock. It was a lot of shell bed, stuff like that. That just you
And
couldn't get through it.
What tools were you using to dig?
A shovel.
Was the shovel going to be able to penetrate through the lime rock to dig, let's say, another 3 or 4 feet down?
Not by me, no. I definitely couldn't do that.
Okay. Judge, may the witness step down and get the picture again.
You may.
So we can show the jury the photographs that we just discussed.
That's fine. Mr. Coates, we're going to be standing over there talking to the jury. Just remember my court reporter's over here. She has to hear you, okay?
Yes, Your Honor.
Thank you.
If you can't hear me, feel free to yell at me and let me know.
Is it too many for you to see on that? Oh, good. I'm showing you what's been entered into evidence at States 258. Can you describe what we're looking at in this photograph?
Can you give me the number again? I'm sorry.
258.
Thank you.
This is the east side of the residence. This area here is the, thank you. This area here is the screened-in patio that contains the pool. This tent here and the sawhorses and these wooden areas are the screens that I was using to actually sift through the dirt. I was digging a hole here. You can actually see my shovel here. Digging a hole here, and then I would take the dirt over here in buckets and sift through it. This pile here is everything that I've removed so far up until that point. But you can see the hole here. It's pretty decent size.
And to be clear, the tent and the sawhorses and the sifter and the shovel we see on the ground there, are those all things that you brought?
Yes, that is all my equipment, including the tarp that's everything's under and everything. This was just a grassy area until I got there.
Okay. So, but by the time this photograph was taken, this area is being disturbed by your search?
Extremely.
Okay. And I'm displaying States 259. Can you tell me what we're looking at there?
Yeah, this is, again, for a point of reference, this is the shovel that I had in there. This is the post from that wooden area. This is the hole that I actually dug. And it's about, I think it's approximately 5 to 6 feet long, 2 to 3 feet wide, and then about 2 to 3 feet deep. Right here, you can see the label. I found it over here, and it was one of those when I dug it up. I opened it up to make sure it was something that maybe I needed or whatnot, and that's what I came across, and I opened it up so I could take a photo of it where it was.
displaying State's Exhibit 260.
And again,
Where is
this is a close-up of the label itself that I just showed you.
And I'm showing you 261.
And then this would be, again, the area of the hole that I haven't done.
Thank you. You can resume your seat.
Thank you.
Did you assist in searching other areas of the residence?
I did.
In particular, did you help search in the master bedroom area on the second floor?
Which room are we referring to? Room G?
Room G on the diagram?
Yes, right here. Yes.
Okay. Now, I've already shown defense counsel what's been marked as State's Exhibit 263. Could you look at that and tell me if you recognize what that is?
Yes,
You recognize that?
I do.
And where did you find that?
It was on the floor, in front of the dresser, on the southwest corner of the room, or southeast corner of the room, I'm sorry.
Okay. And how would you describe it?
It is a broken piece of metal.
All right, Judge, at this time, say we'd like to move this exhibit into evidence.
Any objection?
Here you are.
All right, 63 will come in.
Made a witness step down and publish this to the jury.
You may.
It's a small piece of metal. Everyone can see that. Everyone get a good look? Okay.
Can you tell me what is MC14?
MC 1414.
Correct.
Let me refer to my notes real quick. MC 14 is a swab of the floor in room G. It's one swabbing of the southeast corner next to the dresser.
Okay. Now, approaching you with an item marked State's Exhibit 264. Can you just tell us what 264 looks like right now?
It looks like it's a map of the upstairs of the residence.
Same diagram that we just looked at?
I believe so, yes.
States I'm sorry, States 59. Can you highlight for me the area from which you took the swab on States 264?
Sure.
And if you could, write MC14 next to that.
Sure. Sorry.
Judge, at this time, I would like to move State's Exhibit 264 into evidence.
Any objection? The diagram?
Yes. Move your order.
All right, 264 will come into evidence.
Judge, if I can have just a moment.
Okay. Yeah, 264.
Mr. Coates, to be clear, we did talk about swabs with some of the previous forensic texts, but how did you collect the swab?
This swabbing was an area that we had sprayed with luminol. And so what we did was we basically moistened the swab with distilled water, and then we swabbed the area, we put it back into the package and sealed the package.
Okay, and then you entered the evidence for later testing if necessary as MC14?
Yes, sir.
I don't have any more questions, Judge.
Cross?
Nothing, Your Honor.
All right, Mr. Coates, thank you very much. You may step down. Is he released from his subpoena?
No, Judge, we asked that he remain on
All
standby.
right, just remain on standby, be available by phone, but you're released from the courthouse today.
Thank you, Your Honor.
All right, State, call your next witness.
State will call Susan Miller.
Okay, Susan.
Miller. Yes.
Do we need to approach?
Yes.
Okay.
Some testimony there from one of the forensic examiners, and we've just seen so many of them in this case, but talk about a complex crime scene. You've got 4 victims, you've got blood, I don't want to say all over the crime scene, but in various rooms. You've got garages, bedrooms, master bedrooms, side bedrooms, stairwells. You've got bodies disposed at a remote location about a mile away. You've got evidence thrown in the canal behind the place. You've got bullets stuck in walls in the driveway. You know, this is a case that needs a lot of stitching together from experts.
It definitely does, especially the fact that the murders didn't all occur the same way. You have some were shot, some were beaten, one was possibly asphyxiated. So there's all different types of things. Some people had their skulls beaten in so badly that they couldn't even reconfigure them. So there's a lot of evidence to really digest and to explain to the jury.
What do you make of the causes of death here? Because usually if there's a crime where multiple people are killed, it's all gunshots, it's all one thing or another. In this case, you've got one victim shot in the eye and killed that way. You've got another person shot twice in the back. Another person was beaten severely, and another person both beaten and asphyxiated. you know, is this the kind of thing that maybe the defense might try to turn on and say, there's another possible suspect? This just doesn't make sense, that one person would choose all of these different vehicles.
It's something that they may bring up, but I don't think that's a likely situation for them to bring up. I think that the way, there's been some evidence, not specifically in this case, just generally, that the way people are killed can have an impact or tell you a little bit about the relationship, such as shooting someone so close in the face says that you had a personal relationship with them. Shooting someone in the back tends to show that they were running away or escaping, or they were trying to avoid the confrontation. Beating somebody so bad may show, I mean, in the case here specifically, it's the new boyfriend who is bludgeoned and just really atrociously beaten. So I mean, that could show some anger, that he could have been jealous that this is the new boyfriend, this is the new man in his ex-girlfriend's life, and so he's taking his frustration out that way. So there are a lot of different components here to really take into account and say, well, this could explain why one person, specifically him, why he would have the motive in all of these different situations.
That's an interesting theory, and I'm waiting to see how the state's going to try to bring it all together in closing arguments. But, you know, what do you make of a possible defense strategy here? I've been trying to figure that out. You know, we've got this person in Kansas who apparently was involved in some way with one of the victims, Nick Leonard. You've got strange phone calls being made to the mother of the child here, okay, Megan Brown. And police looked into these as alternate suspects, alternate theories. The defense certainly deposed all these people. The defense wanted to see what was going on here. I'm trying to figure out if the defense is going to try to go there or not, because the person in Kansas was at work, was seen at work. Bottom line, that person in Kansas could not have gone to Florida to commit these crimes. But it raises a lot of questions about what was going on with this group of people.
I think that their only defense is to try to get any blame off of him that they possibly can. And so by putting some of it onto this other person from Kansas, even though she has an alibi for the time, she couldn't have done it, she was in an entirely another state, that might be their best bet, to try to say, oh, look, no, it couldn't have been him. Let's put some, they just have to get some reasonable doubt. So if they can get anyone on the jury to buy their theory that maybe this other woman was somehow related, maybe she didn't do it, maybe she hired a hitman, maybe there were other issues here that we kind of want to look into, that might be their best bet, because as we said earlier, there's so much evidence against him, just so much showing that, you know, he is the one who committed these crimes.
Exactly. Now, look, it may be their best bet, but in my opinion, it's not a winning bet, because there's just so much evidence that seems so clear-cut against this defendant.
Right. But at the end of the day, they have to come up with something. They have to provide a defense. So they can't say, oh, you're right, there's so much evidence here, you got us. You know, they have to find something to say, no, let's look anywhere else. I sat in on a case one time where they tried to say, you know, it wasn't even a person who committed these murders, it was voodoo that did this. And, you know, that was actually the defense that they tried to sell to the jury. And obviously it wasn't a winning defense, but
I was going to say, that's a unique
something.
I haven't heard that one yet, but look, I mean, truth is stranger than fiction. I say
Right.
it time and time again. I see it time and time again. What do you make of the defense not giving an opening statement?
It's a risky move. The prosecution has a lot to say. They're telling the jury, we're going to walk you through this case. Here's the evidence we're going to present to you. Here's why we're right. And for the defense not to have any rebuttal to that and say, here's all the things that they're trying to prove to you, but they're not going to be able to do that. You know, you're leaving, it's risky, because you're leaving the jury with that one opening statement saying, oh, here's our expectations now, let's get on with the trial, and we're expecting to see some evidence against the defendant.
We're going to continue listening to some of the forensic testimony in this case. A reminder, in case you're just joining us, testimony will resume live in this case on Monday. The jury and the court is taking a Veterans Day holiday. We will be back with live testimony on Monday.